Hello, this is Joe Pryor with the virtualrealestateteam.com in Oklahoma City. And I'm here with Henri, and he's just nice and comfortable here, my little poodle, being in the video as always. Here comes Hope, my standard. They always like to help out about video time. I just finished a series on first-time homebuyers and everything that you need to know, some educational advice. And I'm about to start a new series to update short sales, pre-foreclosures, in Oklahoma City, how to avoid them and some of the new programs that are out there and how they're working. But in the meantime, I had some interesting questions from the first-time homebuyer series that resulted in some videos. But the one that I got just a couple of days ago, I think is worth not only a video for first-time homebuyers, but also for anybody coming into the Oklahoma market who is buying a house in Oklahoma and in Oklahoma City area for the first time. And that is, what about representation? Who represents who? How are the rules here different than maybe other states? Now, I started in real estate in 1989. And at that time, everybody represented the seller. That was all there was what we called seller's agency. You had somebody that listed a property, represented the seller. I would come in with a buyer. I would represent the seller as a sub-agent. Nobody represented the buyer, not the mortgage company, the title company, not anybody. But around 1993, in fact, I think it was 1993, a historic case was done in Edina, Minnesota, a suburb of Minneapolis, St. Paul, and against Edina Realty. It was a class action suit based on, hey, there's collusion going on between agents. They can talk to each other about representing the seller, and I'm not being properly represented, and I may have paid too much money for that house. And it was settled out of court. But it was one of those common law decisions that kind of became the law of the land. We call it the water cooler law, or the water cooler rule, actually. It's not a law. And it was this. I mean, if I'm sitting there getting a drink of water or a coffee and somebody comes in and says, hey, Joe, I have this house. It's listed at $200, but you bring it in at $195. We're going to put a contract together. Well, that's not fair to anybody. That's not fair to the seller even, because they're taking $5,000 less than maybe the property's owned is worth. And then the buyer may be paying too much for the house. So they didn't want that anymore. So buyer's agency became the common law of the land based on that case. All of a sudden, we were now representing the buyers and representing the sellers. And that seems fair, a collective bargaining agreement. Now, there was one exclusion to that, and it was called disclosed dual agency. And that was this. If I was listing a property and somebody from my office came in with a buyer and wanted to make an offer, we have a problem because that water cooler law was in effect. And so what we both had to do is step back from the transaction completely, and no one was represented. We became facilitators at that time. Well, it was better than the previous rules that we had, but it still, according to Oklahoma law, was really not good enough. And by the way, disclosed dual agency exists around the country still today. But Oklahoma did something progressive. What they did is they passed statute law that governed realtors and representation. So the law of agency, the common law, was completely eliminated, and we became what was called single-party brokers or transactional brokers. Now, it really freed us up in a lot of ways. For one thing, without this disclosed dual agency, then only one party had to step back if they were from my office. So in other words, either I would step back or they would step back. Somebody would stay in representation. So that was better. The other thing is it strengthened beyond fiduciary duty. For instance, it made it so that I had to obey your request at all time, even stronger than fiduciary, because let me give you an example. Let's say you were looking for a $200,000 house. Say, Joe, that's all I can afford. That's all I want to buy. But I knew you qualified for $300,000. So all I did was show you $250,000 houses. That is a legal violation of the single-party brokerage law, because you didn't ask me to show $250. You asked me to show $200. Now, the other part of that is, now, if you ask me to break the law, of course, if you ask me, well, what is the racial makeup, and I only want so many of this or so many of that, I'm sorry, I don't have to do that. Anything that would violate fair housing, anything that would violate legal statutes, at that point, what I would tell you is, I'm sorry, I can't do that. You need to find someone else. That's not the way I do business. So it is very important that not only you get representation, which this law does, but it also says, hey, if that's what you want and that's what you can afford and those are the instructions, then that's what you give me. Now, transactional brokerage is where I just facilitate. And it's very hard to do. Let me put it that way. It's very, very hard to do. For me not to represent. I can cross the line very easy. If I give you any advice whatsoever, if I say, well, I think you ought to offer this much amount on the property and I'm representing the seller and writing up a contract, I violated it. All I can do is say, write the contract. Now, one kind of cool thing that I do like about our laws is that if I'm listing a property and you want to buy with me, now I'm always going to tell you that you have the right to seek representation with another realtor. That will not affect the transaction. I'm not trying to force you to deal with me. I'm not trying to get more commission out of the deal. I'm trying to do the right thing, the legal thing, and the ethical thing, but you still want to write a contract with me. I can give you comparables. I can give you some information. I can talk to you about repairs. I can talk to you about title. I can talk to you about, giving you some choices on some lenders. We just can't touch that price. And I can't tell you what to do or advise you what to do. And if you tell me, I'm going to offer X number, but I'll go up $5,000, then I'm going to say, I'm sorry, we can't do business anymore because I've got to tell my seller that. I've got to tell them everything that you're telling me right now. Very hard thing to do, transactional brokerage. Most of the time in Oklahoma, somebody is representing somebody, a buyer on one side, a seller on the other. Normally, we can put together a deal that is fair where everybody wins. I think that's the object of this. And that we have even stronger laws of representation than almost any state in the union. I don't think there's a better place than Oklahoma for you to come and talk to a realtor and have more guarantees that we're going to take your best interest at heart than any other place. And if we don't, guess what? It's not just an ethical violation. It can be a legal violation. So that's representation in the state of Oklahoma. We hope that when you come into the state, you love what we love about it, that you know that you are going to be properly represented. And we'll go over this with more detail. And in fact, we'll even do something in writing so you can see everything on paper. This is Joe Pryor with the virtualrealestateteam.com in Oklahoma City, where we deliver traditional real estate values with the speed of technology.